So we're going to talk this afternoon now about supplier contracts and indemnities. It's hardly sex, drugs and rock and roll. But to the defendant community, this is really important. And again, I really enjoyed this. I mean, I haven't had to speak in serious and substantive, which is always a good move. And I'm really learning so much. And again, thank you to Sara-Jane and to Craig for coming along and helping us put this on. Many of you will know Sara-Jane. She's a partner and head of the European group at DWF. She's done this kind of work for a long, long time and is a true expert, as is Craig Evans. He's a partner in the casualty and healthcare team at Clyde & Co. He routinely deals with cases of this kind and is one of Clyde's leading lawyers in this sort of work for the insurers that they all act for. Which leaves Sarah Crowther. Sarah's always anxious as to what I'm going to say about. She is simply the best travel law and complex silk I know. So.
Oh, thank you, Joe. You almost let me speak. Almost. Thank you very much. I'm very grateful for that introduction. I was just thinking, Sara-Jane and I were talking in the break just now about when we first worked together, and I think it was when I was a pupil, or maybe just when I've been taken on as a tenant, and in 2000, which that's when the world was in black and white, for some of you. And I think the first case we did, we had to go to Milton Keynes, and Sara-Jane was not only my instructing sister, but she was also my witness, because the case concerned the allegation that you compromised case that was disputed. So I had to put you on the witness stand and engage in cross-examination, which we did win. And then after that, I think you sent me a case about an exploding caravan. Is that right? Yes. So, if you wonder how I got here. We never did find out where the caravan exploded. No. So we were going to talk about how, from a tour operator usually perspective, where there's an accident claim, what the options are for a tour operator in terms of joining a supplier, possibly to an action, or taking other steps in order to ensure indemnity. Don't all switch off if you're a claimant lawyer. The reason I say that is because actually it's really important, I think, when you're acting on behalf of claimants and bringing claims against tour operators, to have some insight into what's going on behind the scenes from the defendant's perspective. It does play out in the course of litigation vis-a-vis the claimant, particularly on issues like disclosure and access to evidence, and also more directly on timetabling and things like that. So I think it is very worthwhile, and also when it comes to the settlement end of a claim, to have an idea on, well, what might be going on in terms of the indemnity and the discussions in the background. That can be quite a useful part of the information jigsaw when you're approaching settlement. I'm going to talk a little bit about some of the kind of nuts and bolts of the kind of legal principles that apply when a tour operator is looking at options. Craig is going to give us a bit more of the useful insight into how you actually go about it from a tour operator's or a supplier's perspective on what goes on. And then Sara-Jane is going to talk a little bit about some of the practicalities when acting for particularly foreign insurers and other foreign clients, and what they really think about being dragged into the English litigation process and what's going on in their minds. So, is this clicker working? Did we? I'm pretending to do it. I say, next slide, please. Okay. Jurisdiction. If you're a tour operator and you've got a claim form in from a claimant or claimants who've had an accident or illness, and you're looking at potential proceedings against the supplier, what can you do? Well, the first thing to think about is it possible to bring an action here in England and Wales, or does the action need to be in the courts of another country, potentially the country where the events giving rise to damage occurred? So you need to have gateway for jurisdiction. You need to be able to establish reasonable prospects of success on that action. You need to be able to establish that England and Wales is the proper place for the claim. And even when you've done all of that, the court will have a residual discretion as to whether to allow you in or not. Next slide. So, in contrast to claimants, a lot of the time when you're acting on behalf of a tour operator is you'll be starting from a contract perspective. And the relevant ground here is in Practice Direction 6B, and it's 3.1, but it's paragraph 6. And you can establish in principle jurisdiction in respect of a contract where it was made within the jurisdiction or concluded by the acceptance of an offer which was received within the jurisdiction. That feels like a very kind of wordy and over the top rule. And part of the reason for that is that the previous iteration of the rule was subject of some criticism by the Supreme Court in Lady Brownlie's case, the first time it went to the Supreme Court, so before I was involved in it. But there was extensive debate at that point about a telephone conversation which had taken place between Lady Brownlie when she was at her home in London on the telephone to the concierge desk at the Four Seasons in Cairo. And as the Supreme Court pointed out, it seemed a bit odd that the question of jurisdiction might turn on the distinction between whether Lady Brownlie had asked for them to arrange the safari tour or whether they had offered to arrange the safari tour in a conversation that had taken place several years before, and frankly there was practically little direct evidence of. So now the wording is wider, and either it's a contract made here or where there's an offer which has been received here, which has been accepted. Don't forget, you can also bring a claim in respect to contracts where the agent has made them and the agent is trading or residing here. That can be quite important in travel because there are very often and complex structures sitting behind different components of travel packages, and agents are very often involved in bed booking services or other kind of business to business suppliers who are in the chain. And so that can be quite a useful route if you're a tour operator. You need to make sure that you've got full overview of exactly how the contractual situation played out. Most importantly, and I think Craig is going to tell you more about this in practice, if you've got a contract which is governed by the law of England and Wales, then that will give you gateway jurisdiction. I've included breach of contract committed within the jurisdiction on this slide. It's not going to come up very often in this context, but that is also a potential ground. Obviously, if you have a contract and you have got a clause which is about jurisdiction, so an agreement as to forum as opposed to applicable law, then that is of itself separately a basis for the courts to have jurisdiction in principle. I've included the tort gateway on the next slide. It's not going to be as important in terms of recovery actions, but you must never forget that it exists. There is a case which says that if you can bring your claim in contract and in tort, then you can choose. And so there may be circumstances in which, for whatever reason, the tortious claim is more generous, maybe limitation or damages. So it's not going to be your first go-to, but you shouldn't forget that that might be an avenue. And we know from Brownlie number 2 that in terms of gateway threshold, that's relatively low now. It's any non-insignificant damage. More interestingly, and this is something that I think Sara-Jane is going to tell you a bit more about in due course, is the ground which allows for additional claims. So this is Practice Direction 6B, but now we're into paragraph 4 of 3.1, which says that any claim which is an additional claim and the person to be served is a necessary or proper party to the claim or additional claim, CPR Part 20 tells us that an additional claim is very widely drawn, so that means any claim other than a claim by the claimant against the defendant. So it definitely includes a claim by the defendant against a third party for a contribution or an indemnity. So in principle, the courts will have jurisdiction to hear that as long as you can demonstrate that they are a necessary or proper party. Just on that question of what is necessary, just lost my slides on here because I clicked the wrong button. Let's go back to that. Necessity is quite a high threshold. I mean, you need to demonstrate that basically the proceedings couldn't go ahead without the third party being joined. I can't off the top of my head think of the circumstance where in travel that would be easily fulfilled. And in the case that I've put on the bottom of that slide, the CH offshore case, Mrs. Justice Carr made also the point that this is potentially quite a wide gateway. So the courts might be more scrupulous in determining the question of whether somebody is a proper party to the claim. The test is there a single investigation which needs to be carried out in respect of both the main claim and the third party claim? Or are the claims closely bound up by a common thread, which sounds a bit rumpled, but I think basically what it means is that you've got issues in common, or perhaps a risk of irreconcilable judgments if the proceedings were to go ahead separately in different countries. At this point, of course, if you've got an exclusion clause, an exclusive jurisdiction clause in favour of a different country other than England and Wales, then that is going to be unhelpful in terms of jurisdiction for your question of whether the third party is a proper party to the claim. So in practice, if you're looking at contribution or indemnity proceedings, you're going to be looking at ground 4 and you're going to be exploring, well, what are the issues? What is the overlap? Is it all basically about the same thing? Is there a risk that if the courts in Spain and England hear these proceedings separately, they'll reach different outcomes? In which case there's a good chance that you'll be able to cross over the proper party threshold. And then in terms of any application for permission to serve a claim form out on a third party, if there is a foreign law which applies, then you need to have in mind at the time of that application what foreign law evidence you might need to be drawing to the court's attention in support. Obviously, applications for permission to serve out are generally done without notice. They can be done on notice, but they're generally done without notice. That means there's an obligation of full and frank disclosure. If a law other than English law applies, then one of the considerations the court is going to have is to what extent is that going to make a difference to the proceedings, because if it's Spanish law, for example, then the Spanish courts are generally speaking better placed to determine issues of Spanish law than an English court would be. On the other hand, if the Spanish law and the English law don't really make much difference on the facts that are contested in the case, then the application of Spanish law may be a consideration, but not a particularly material one. So you do need to have thought through what the cause of action is going to be, what issues might need to be pleaded. I've put some issues up there just as the kind of thing that comes up. But in practice, the closer foreign law is to the English law, then the easier it is to argue that it isn't a materially significant factor in the foreign convenience discussion, and the easier it will be to persuade a court that England is the proper place for your third party claim. That is kind of whistle-stop tour, kind of the overview. I'm now going to hand over to Craig, because Craig can actually put a bit of flesh on the bones of that, I hope, and also give you a bit of more meaningful insight into what's really going through the tour operator's mind when they're making those decisions.
Thank you. First of all, I take some slight objection to Gerard's comment that it's not sex, drugs and rock and roll. In fact, the majority of the cases that we come across involve some elements of sex, drugs, or rock and roll. But sadly, I'm not going to be talking about any of those today. But in the positive, what I am going to be not talking about is too many regulations or law. I'm going to look at it from a very practical point of view. We're going to be looking at it from the suppliers and tour operators' point of view of when a supplier should take conduct of a claim, what reasons not to take conduct of a claim, I'm going to bring it all back to one case example that incorporates a lot of the issues I've been talking about. As Sarah and Gerard said at the start, it is very relevant from the claimant's perspective. If you kind of think of it, you've got a tour operator in the frame, you want to bring a claim against a tour operator. The package travel regulations are very consumer-friendly regulations designed to make it easier to have a claim in this country against a tour operator. In reality, particularly on larger cases, a tour operator isn't going to settle a claim until they've got their ducks in line in relation to the supplier indemnities and they know they're going to get paid in relation to the contracts from their suppliers. This can add significant timescales to your frame. And also, when we come to discuss about conduct of a claim, it might not matter too much to you, but it depends who's actually handling your claim. Is it going to be the lawyers for the tour operator, or are the lawyers for the insurer of the supplier going to take over conduct of the claim? So it is quite relevant from a claim perspective. Okay. Often what a tour operator wants from a commercial contract with a supplier can be very different to what a supplier wants from a contract with a tour operator. From a tour operator's perspective, as I touched on before, a good indemnity clause would ordinarily give the principal foundation for any additional claim, with accompanying alternative claim for an indemnity or contribution pursuant to the Civil Liability Contribution Act. The wording needs to be drafted very clear so there's potential recourse to add the supplier to the claim. A tour operator now will want the hotel or the supplier to be liable for any and all damage and costs that the tour operator will be responsible for. I've seen many examples of cases where a claim has been brought against the tour operator, no legal judgment has been entered by the tour operator, they've settled the claim on their own volition on risk grounds, and the tour operator has come to recover its cost from the at-fault supplier. Because of the wording of the contract, the supplier has rejected the claim and said there's no contractual indemnity. This wasn't triggered because there's no legal fault, and so the tour operator then is liable to absorb the cost of the litigation. I won't go into too much detail about X and Kuani. I'm sure James can talk about that over drinks later. But I will say that as the comments there from Lloyd Jones there, that taking a broad view of the obligations of a tour operator, coupled with the narrow view of the defence under Regulation 15(2)(c), this leaves the tour operator from risk of both deliberate and negligent acts, not just from the supplier, but the supplier's employers and the supplier's subcontractors, as in that case. So it's really important that the tour operator gets in their contract an indemnity that not only covers the fault of the supplier, but also their employers and external contractors. A second key consideration that we need to look at is choice of law and jurisdiction. It may be that the choice of law for the contract is very different to where the supplier is based. A UK tour operator will always want a contract in place that's governed by the laws of England and Wales and subject to that exclusive jurisdiction. Obviously, you may have a supplier who's, say, based in Spain and they contract to many different tour operators. That doesn't work quite so well for them. I've got a recent case at the moment in relation to a supplier contract where there's an exclusive jurisdiction and an exclusive choice of law in relation to the courts of Finland. There was a tour operator based in the UK. However, the supplier contract they had with their supplier had this exclusive jurisdiction clause in there. Despite the indemnity being unlimited and very strong, it was very difficult, if not impossible, to bring the supplier before the courts of England and Wales. Where there's an exclusive jurisdiction clause in favour of another country, it's not a determinative factor, but it's very critical in obtaining jurisdiction. I'll refer you all to the case of Young and HSBC there for more recourse on that. Of course, with tour operators in the UK, they tend to be quite large commercial entities, and they do tend to get their way, most of all, with applicable law and jurisdiction in these contracts. But you do need to be aware if you do get a contract like that to know you handle a claim when there's an exclusive jurisdiction clause for another jurisdiction. Another issue that can arise with indemnity agreements when there's no clear contract between the tour operator and the at-fault supplier. There's often relationships with bed bank suppliers. These operate business to business and not directly to consumers. In the absence of a direct contract between the tour operator and the at-fault supplier, then there can be issues there in relation to forcing an indemnity or bringing the supplier into the litigation. I think Sara-Jane's going to talk about Regulation 29 later, which may help to fill in that gap. And lastly, another issue to consider is claims handling procedures between tour operators and suppliers. Where there's a protocol between the supplier and the tour operator in relation to claims handling, this resolves many of the issues that we will discuss today, and it makes the process much, much easier. A claims handling protocol will cover things such as when notification needs to be given of a claim. Quite often, the tour operator will know about a claim before the hotel. Sometimes the hotel will not even know about the claim until they find that they've got an issue claim on their desk. If you have this protocol in place, it gives obligations between the two. A good protocol should also give the supplier the option of taking conduct of the claim, and then they can decide if to do the claim that way. What we often see at the moment without this protocol is a supplier at the end of the claim challenging the way that the claim has been handled. They'll say it's an implied term of the supplier contract for the tour operator to handle the claim with reasonable skill and care. If maybe liability has been admitted without recourse to them or offers have been made without recourse to the supplier, they can challenge this, and this can sometimes be problematic for the tour operator. By setting clear guidelines for the handling of the claims at the onset, this can really remove those issues. Thank you. Okay, when should a supplier take ownership of the claim? So a supplier will certainly have notification obligations in its contract of insurance. When we say the supplier is taking ownership of the claim, in reality, it's the insurer of the supplier who's taking ownership of the claim. And so if there are notification obligations in their contract of insurance, the supplier needs to ensure that similar provisions are within the contract of the tour operator. That is, if the tour operator doesn't notify them of the claim, the indemnity can fall by the wayside. Public liability insurers of suppliers recognise that their insured will ultimately be responsible for this claim on the basis of the indemnity, and they'll be expected to pay damages later down the line. A public liability insurer, if they're going to be the ultimate paying party, always wants to have control of the claim. They want to control if liability is admitted, they want to control the level of damages, and more important, they want to control their own legal costs. Insurers always want that control, and it's really important. Secondly, if there's a dispute to liability or a very high quantum to the claim, again, the insurers of the supplier will wish to take conduct of the claim. This is twofold, really. Again, firstly, because if they're going to be the paying party, they want to try and limit their exposure and make sure they're controlled what is spent. And secondly, if they've got skin in the game and they've also got closer relationships with the supplier, it's going to be easier for the supplier and their insurers' lawyers to obtain evidence, retain evidence, get witnesses from the hotel staff, get the documentation that's needed. Quite often in these cases, we see that the tour operator leaves their request for information from the supplier quite late. It puts a lot of pressure on the supplier, and there's a breakdown in the relationship between the two. What happens in those cases is evidence that can be used to defend the claim goes missing by the wayside, and the claim is ultimately settled. Also, tour operators need to be receptive to the supplier taking conduct in these issues, because if the supplier doesn't take conduct, then the tour operator may have to bring the contribution claim against the supplier. If a tour operator brings a contribution claim against the supplier, it's of course not protected by quotes. And so that's more risk again for the tour operator, and again, more additional cost. As we discussed about having effective handling procedures and a protocol in place, if this is in place from the onset, again, it's another positive reason why a supplier may want to take conduct, and the tour operator will be happier for the supplier to take conduct. Both parties know what their obligations are, and both parties know what they need to do. The tour operators knowing that they're going to be indemnified, and the supplier does have conduct and its insurers to limit what exposure and what's paying on the claim. Okay, when would a supplier not wish to take conduct of the claim? Suppliers can often have very low levels of indemnity on their insurance policies. We see some very, very high claims that can be levels of indemnity as low as €100,000, which is clearly not adequate for the claim. It makes very little sense then for the supplier's insurers if they have a low level of indemnity on a claim, and it's a very high value catastrophic claim, to take ownership of the claim. In these cases, what we'd expect to see is that the supplier's insurer will pay up their indemnity level, and then the tour operator is left with a difficult scenario where they have a supplier who is no longer without insurance. And what the suppliers usually do in these situations is put their hands up and say, we have got no money. If you try to bring a claim against us, it's going to be almost impossible to enforce, and we'll simply go bust. And so that adds significant delay to the claim where the tour operator works out if they can really pursue the hotel who has no further insurance. Also, what we quite often see in claims is layers of insurance. You can have a high value claim and there'll be three different insurers. One insurer will cover, say, the first €600,000, the second insurer, the second lot, and be a third insurer after that. This level of reinsurance, again, causes more complications in terms of handling, because the insurers will be fighting amongst themselves over who handles the claim. The first insurer will say, we're trying to keep it under the first threshold, when in reality, it's a high value claim and it goes quickly above that. And so this adds more delay and issues into the claim, which a claimant may not realise, but again, it's pushing the settlement date further down the line. Again, we touched on late notification. If there's late notification of a claim from a tour operator to a supplier, this prejudices the supplier's ability to take conduct and assist in the defence. So again, it's a reason why you can withdraw indemnity or not wish to take conduct of the claim. We've mentioned as well that quite often a tour operator and supplier will have an issue on the handling of a claim. I've seen quite often the tour operator just present to a supplier a bill at the end, and the supplier's had little, if no, input whatsoever into the case. Again, the supplier then may raise the issue of that the handling of the claim wasn't sufficient and it wasn't as part of the contract. It was implied to him with the contract that it needed to be handled with reasonable skill and care, and that wasn't the case. Again, it's a reason why indemnity can be withdrawn. And there are times when a supplier taking conduct of the claim would literally cause major disruptions to a case. I've been instructed previously by insurers of the supplier to take conduct of a claim a week before trial. It's pointless, absolutely pointless. There's nothing you can add to the claim then. It's going to add more cost. You're going to do more harm than good to the defence. The tour operator's lawyers at that stage are more than adequate and in a far better place than you are to take up conduct and deal with the case. Okay, so I'm going to give you a background now and bring you into a real life example of a case. I'm a little bit disappointed that Ali is not here actually, because she was on the claim front here alongside Harry. And I wanted to use this example as almost an apology for why it took so long to settle this case, and so she could understand the complications that we had. It's quite a difficult case. I'll give you some brief background. It's a young girl on holiday in Spain. She's with her family. She went to the pool and her parents weren't looking after her, and the lifeguard didn't notice that she was on the bottom of the pool for a period of time. She suffered a brain injury, and it's alleged that the hotel and the lifeguards were at fault. The litigation involved multiple parties: the tour operator, the hotel, the lifeguard company, and the litigation also involved different applicable law. There was a package travel regulation claim against the tour operator, and there was a Spanish law claim against the Spanish law defendants. So this is just to kind of highlight how difficult and complicated this case was. Initially, the claimant presented their claim against the English-based tour operator. English law applied to that claim. In addition, the claim was presented against the hotel's insurer. The hotel had a limit of indemnity on this claim. It's a child brain injury case, so bear that in mind for the value. Approximate value around about £8 million. I think their level of indemnity was about €130,000. And so they quickly paid their level of indemnity, exited the claim. That left the hotel in the claim. The hotel stated that they were essentially in pecuniasis. They had not very much money at all, and they certainly couldn't satisfy a large portion of the judgment. In addition, the claim was brought against the lifeguard company, who didn't really engage in the claim whatsoever. The lifeguard company's insurers did engage in the claim. However, the lifeguard company's insurers, they probably had an indemnity which probably worth about a third of the total value of the claim. And so you can see there's a lot of pressure on the English law side here. So the tour operator from the English law side, they had an indemnity against an accommodation wholesaler. While it's an alleged indemnity, this was disputed by the accommodation wholesaler. The accommodation wholesaler stated that if the tour operator was in fact acting as a tour operator, then the indemnity wasn't valid. There was issues of late notification, as we've discussed. There's also issues in the contract in relation to if the tour operator was adding a surcharge in relation to the price the wholesaler was charging the tour operator. So this indemnity was disputed on this part. The accommodation wholesaler brought in a fourth party, the bed bank. Luckily, their indemnity was covered by English law and English choice of jurisdiction, so they could be added to the claim quite easily. The fourth party bed bank, when they were brought to the claim, they didn't want to be left at the bottom of this chain, because you can see the potential very high exposure if you're at the bottom of this chain. They did have an indemnity against the hotel. We know the hotel's got not much money left, and they've used all their insurance. And to make matters even more complicated, the indemnity contract there was governed by an exclusive jurisdictional clause in Mallorca. And so the hotel in this situation initially stated, we're going to dispute jurisdiction and argue jurisdiction and argue that the contract is valid. And so you can see the plethora of different issues you've got there. Just from that example, you can see all the different applications, cross applications that were made. You're the claimant, an innocent claimant who wants to get your damages. you've got no idea what's going on in this scenario here. There's lots of different parties that need to get their position in line. During this claim, we tried to go to JSMs, and the JSMs organised. I think there were 4 cases and 4 very senior juniors on this case. You can imagine the cost of a JSM. I think someone described it to me like herding cats, and I think that's a disservice to cats. Joe, I just want to see my cat. I can train my cat to do a high five and tricks. We couldn't train anyone to do anything in this case. It was very difficult to get that. We had a trial date booked. 2 days before trial, we settled the claim. The claimant thought they'd settled their claim. Then straight after we'd missed the trial date because the claimant settled, the defendants had decided between them and the claimant, actually, we haven't settled the claim because we can't get an agreement between us all. And so the claimant had to make an application to relist the trial. Luckily, in that time period, the defendants eventually did get together because the issue is the tour operator doesn't want to be left holding the can for the whole claim. If there are indemnities in place, even though there are arguments, they want to make sure that the money is being filtered back that way. And so before the claim can be settled with the claimant, it needs to be settled with all the other parties, and there was a contribution agreed between the all parties. We'll just move to the next slide. And I think the issue to say, when you get a situation like that with indemnity contracts in these kind of claims and supply relationships, it really does add significant amount of costs and it adds significant amount of time. And I think the defendants do lose sight of the fact that there was an innocent claimant on board there who want to access their damages. And it's probably more of a fault with the regulations, as I said at the start, because package travel regulations are meant to help the consumer. And by bringing the claim against the tour operator, it's meant to be an easy way for access to justice. But the tour operator doesn't want to be left carrying the can with these indemnity contracts. And as we've seen, it's more difficult now to bring the other parties to the English courts and then always use an enforcement. And so whilst it did work in this claim that all the indemnities didn't mean that the risk was shared between different parties, it did add to cost and time. Thank you.
Then Sara-Jane.
Lovely, thank you. Well, that was incredibly complicated. My talk is not. I'm going to be dealing with the rights of redress and contribution and also looking at the defendant's perspective. So I think we've already mentioned several times now that the last few years, COVID era for tour operators and the travel industry generally has been incredibly turbulent. And there are a few cases that have popped up just after this, and one of the cases I'll look at is On the Beach Limited and Others versus Ryanair Limited. I'm sure you're aware of that case, but that's the one that looks at Regulation 29 of the package travel regulations, and whether that creates a standalone right of redress against third parties, excuse me, by way of statutory right. I'll also briefly look at X versus Q only, but on slide 2, please. Oh, sorry, that's what I've just said. Slide 2. I'll be looking at the case of the Natalie Lane Soldiers, Sailors, Airmen and Families Association versus Allgemeines Krankenhaus Pearson GmbH. And that case actually isn't a travel case at all, but I just wanted to mention it because I think it is an important case and probably will only have an effect really with regard to long tail claims now, but it involved a brain injury alleged to have been sustained through the negligence of a midwife at a German hospital by the claimant whose father was stationed in the in Germany and UK armed forces. And in that case, it was accepted that German law would apply to the alleged negligence claim and against the company that operated the hospital. But what's the important feature of that claim, or that case, or that judgment rather, is that the contribution, the Civil Liability and Contribution Act 1978, which is what the claimants were trying to avail themselves of to claim, to make a claim, as though it were brought in England and Wales, irrespective of the governing law, failed. And it was held that the 1978 Act did not have overriding effect, which also meant claimants had to look at German law, and unfortunately, they were statute barred under German law. So it's a Supreme Court decision that is of significance across border cases. And as I say, it's probably a bit little relevance in the sense that since 2009, Rome 2 has come in, Rome 1, And of course, the practical effect of SSFA, the result in SSAFA and Rome 2 is that a tour operator or in package travel claim can rely on the law of England and Wales, although there's that difficulty with dealing with looking at local standards, which is always been mentioned by Dan Clark and Neil Pay. But in effect, you know, it's a lot simpler under Rome 2, and they'll be basically dealing with the claim under English law. But in cases where the package travel regulations don't apply, then you're looking at Rome 2, Rome 1 potentially, and any previous contractual arrangement. And I think where there is a chance that a foreign law will apply, then it's very important to get input from a local lawyer as soon as possible, whether you're claiming or defendant. And if you move to the next slide, please. So looking at going back to On the Beach, that was fairly recent and concerned online travel agents operating websites for booking travel services offered by third parties such as airlines. And On the Beach specialised in package holidays and paid Ryanair in full at the time of the booking with a corporate payment card. And was unable to claim chargebacks, and On the Beach claimed compensation in excess of 2 million under the regulation 29 package travel regulations for the cancelled flights during COVID. And of course, looking at regulation 29, that states that an organiser or retailer may seek redress from any third parties which contributed to the event triggering compensation, a price reduction or other obligations. And in this case, it was really just the High Court ruling on a preliminary issue. They decided that regulation did provide a freestanding statutory right of redress for package travel organisers and retailers against third parties who have brought about losses sustained by those organisers and retailers. And the High Court's judgment is obviously going to be helpful and binding on the lower courts. It will definitely provide assistance to those who organise packages. COVID was an unusual situation, so how it will be used again, we'll see. But what it does bring about is the fact that third parties may be in the frame, irrespective of where they are and who they are. So, for example, could you envisage a fellow passenger who falls ill, causing the cancellation of the flight, triggering an obligation to pay compensation? Is it right that On the Beach, that decision creates almost in effect a no-fault liability for anyone who might be said to have contributed to the relevant event? In my view, the words "may seek redress" are not particularly strong, but we should probably query whether it really was the intention of the legislature to create a brand new cause of action beyond the contractual and non-contractual obligations which already exist between the parties. So, the High Court judgment has come at a crucial time, because I think Karin mentioned the Department of Business and Trade have made a call for evidence to update package travel regulations, and I think they will be looking at regulation 29, whether that will be removed. I think that's unlikely. I would imagine perhaps greater strength will be given to it, but also clarity will be required so that its impact is clear to all parties, whether they're package travel organisers, agents, consumers, or third parties. So I know that the DBT is seeking to get to recover the consumer views on financial protection, alongside I think 150 industry responses to their call for evidence, and that's going to be coming out sometime this year. So it should be quite interesting what happens. But I think, as touched upon earlier, I think a lot of us in the audience, and I do defendant work mainly, but I also do claimant work, and I do think the DPT hopefully will continue the strength of support to consumers in the package travel reform. And I think it's entirely understandable that that should apply whether, irrespective of the price of the holiday or whether it's domestic. Next slide, please. So just looking at, we've also talked about X versus Q only, a very crucial case and one that really troubles in many ways the travel industry and stakeholders, because as you know, the tour operator was liable for serious sexual assault perpetrated on a holiday maker by a member of staff at the resort. And the way in which courts have looked at the responsibility is very widely interpreted in the claimant's favour, and we're looking at the defences open to the organiser, as said before. What falls outside of scope of the package, that will be interpreted very construed very narrowly. So it is a bit of a worry, and probably is something that does keep tour operators awake at night, and insurers generally, especially suppliers, insurers of suppliers, although often their policies have very low levels of cover. And I think what's really important from my perspective when I deal with claims as a claimant, I think we can assist defendants, because what's key is to try and simplify matters. Craig's case was just a perfect example really of how complicated it can be. And I think what worries clients the most is that they have got the right reserves, that they've got the money to meet these claims. And lots of defendants and insurers really worry about that. And that's very important to them. And I think the way that claimant solicitors can assist is by really producing at an early stage with early level of cooperation, very detailed or particularized schedules of loss, which maybe are more realistic rather than what the claimant hopes to get. Because I think most defendants, I mean, perhaps there are some exceptions, but most defendants will want to settle the claims, go to ADR, and I think claimants and their solicitors can certainly help on that front. I wanted just to mention as well the very important point that claimant solicitors need to check that there are no fundamental dishonesty issues, because I think we're all probably aware of the decision of Williams Henry versus Associated British Courts. Now that came out earlier this month, and this claimant, who had obviously lied several times to her medical experts, was actually deprived of her damages in total. And the judge found that it would not be a substantial injustice for her to lose her damages because of fundamental dishonesty under the Criminal Justice and Courts Act. And I think, you know, it's all about knowing your client. If you are a claimant solicitor, making sure that you know your client, that he or she is not lying. And I know that's very difficult to do. Generally, if you know your own client and your opponent, then I think it makes everybody's lives a lot easier. Thank you.
Thank you very much. Thank you, Sara-Jane. Thank you, Craig. Does anybody have any questions? Yes, Ian.
It's a question for Craig. That's please. Following on from your talk with Claire last year, actually.
This is a very delayed question.
Actually, the first guest speakers we invited in back-to-back years.
When you talked about cooperation, Lorna and I were whispering at the back and saying how useful this talk was, because very often when you're acting for a defendant, you can understand why, for a defendant or operator, you can understand why you're not settling the case. And it may be that the tour operator can see the risks, but there are others involved down the chain who take a different view. And the claimant can sometimes take the view that, well, what's the defendant thinking? And in terms of trying to keep the relationship going with the claimant, how do you navigate that? Perhaps as a tour operator, you can see the risk, but perhaps suppliers can't.
It's a very difficult balancing act, and I'd say I'll answer a slightly different question before I come to kind of that one.
It's going to get even more delayed, isn't it?
In these kind of cases, you're often dealing with lawyers from different jurisdictions and overseas who see the claim very, very differently to how you see the claim, as you rightly pointed out. And I think the most difficult relationships, lawyer to lawyer, on that are between the defendants. I think on that example I gave there, you got some people from different jurisdictions who are very, very entrenched in their position, and it made conversations very, very difficult. Even when some of the lawyers based over here in this jurisdiction, people take a position. I'm not going to blame the lawyers because you are taking your client's instructions, but you're dealing with overseas clients who have different ways, and that puts you in a very difficult position. The tour operator who's dealing with the claimant direct, they have to try and explain all that to the claimant. And I think you have to be as open and honest as you can do. You can say, we do want to settle this claim. We want to settle this claim as quickly as possible, but these are the issues. And you need to have a good, open, honest relationship, again, as we discussed last year, with your counterparts. And hopefully they will understand what the issues are then. There's no one from a claimant perspective who's completely unreasonable who can't see this. Everyone's working to the same goal, but if the claimant understands the difficulties in the case and you are dealing with both foreign lawyers, foreign insurers and foreign suppliers, then the claimant will sometimes give you more leeway.
Sarah, I just wanted to follow on from that if I could. Thank you. I said at the start it would be interesting for us, predominantly claimant lawyers, not predominantly, but quite a lot of us, to hear of the difficulties at your end. And I can bring to mind two particular cases that I can think of. One, I just settled the claim with a period of payments of 1.1 million a year. And it was explained to us by Stephen Grime and by some more work that actually we needed to understand how many insurers they had in the room and how many reinsurers. And I think perhaps it is easy, even when you've done a lot of cases like I have, to forget that. But the other case I just wanted to mention, as Sarah is very aware, is that for the last 7 years, I've acted for 90% of the victims of the Grenfell Tower fire. And we went into ADR around 2020. It took us 3 years, ultimately, 2 years of complex ADR. And it occurred to me, while it was playing actually, that one of the biggest issues, and of course dealing with where we were instructed, Clyde were probably in there somewhere, and it was the contribution proceedings. Contributions that were perhaps more difficult, first of all, in getting offers to us, in getting agreement. And I'm going to a question in a moment rather than just my anecdote about getting involved. And to what extent in ADR do you ever, or would you think it would be a good idea to include the whole of the defendant's room in ADR, as well as just defendant and claimant? What do I mean by that? In Grenfell, we were fortunate to have a commercial mediator, Bill Marsh, and David Weaver. And they were mediating with us, but also mediating between defendants. Do you use ADR between defendants in those circumstances?
Yes, I think it's really useful to try and get all the defendants in the room. And I think in the case that I used there, what start questions you have to start? Do you get an agreement with the defendants first of all, then go to the claimants as you've apportioned up the percentages, then go to the claimants to try and get the deal with the claimants? Or do you get to deal with the claimant first, then try and go and deal it up with the defendants? 2 ways of looking at it. But I find it really useful to get all the defendants in one room and try to get on the same page. And I think having you all in the room, it encourages open, honest conversation, and you can understand what the issues are. I think the worst kind of ADR or JSMs I've had, where you have one person going to every different room, it's Chinese whispers. And I think they don't result in success most of the time. It's when you get the same defendants in one room, you've got more chance of getting success, I think.
And my take is that in the defendant's room, there's a real nervousness about making an offer, particularly how people in that's involved. Great nervousness about making an offer before you've got the contributions pinned out. I mean, seriously, I thought listening to you both, it informed me quite a lot really about reminding yourself in the bigger cases and certainly multi-party cases, how much you've got to almost make allowance for the fact defendants have got to get to it. And I suppose also in many of the cases that you get involved, certainly now, we had reinsurers all over the world, Japan, America. We had American defendants, we had French defendants, we had a multiplicity. And time differences made an impact. And are there mediators that specialize in that, or do you just get mediators in? Because actually you need someone who has an appreciation of the difficulties as well if you're going to have an effective mediation.
Yeah, you certainly do, and there are mediators who are better than that. I wouldn't say specialists as such, but mediators who are more aware of those kind of concerns and are better than that, definitely.
I'm sorry about hijacking that, but I was really struck by it. And Sara-Jane, do you come across that sort of thing as well?
Absolutely. I think the thing is when you're dealing with foreign insurers, you know, it's just going back to base and really ensuring that they understand how things work here and that they can't help but be influenced by their own laws and jurisdictions. So that's really tricky. And then they're always taken by surprise, shall we say, by horses here.
Yes.
Unless they're, you know, from the US, or, you know, but if they are in Europe, then it's always a little bit more expensive here and getting.
Well, again, my experience of some of the bigger cases is that although you may be applying their law, you're applying it in England and Wales. And we do rather better at restitution and integrity in England and Wales than in many other continental jurisdictions. And yeah, as to costs, I can't resist another story, which is I settled a claim against a Portuguese insurer by accepting a Part 36. I remember the other side, but I went to not really. I do. And then they came in off with £13,000 or €13,000 costs because that's what you would have got in Portugal. And it took to the Court of Appeal till they finally gave up and realised they would have to pay £2 million that cost. They don't understand costs at all, do they?
No, it's the hardest part of our job, I'd say, without a doubt. It's
the adversarial nature of our system versus their inquisitorial, which, you know, is largely done on paper and they really don't get the costs and don't want to pay them. So yeah, so you have to have some sympathy for defendants.
Laura.
Say I'm drafting a letter before claim for a claimant and it's going to one defendant who is a tour operator with English instructed lawyers. If I'm starting from the presumption that this is, I need to spell out my allegations, but this is going to English lawyers, so I'm not going to write in a way that I would worry would sound sort of patronising or just telling you things you already know. On the basis of what you're saying about the number of almost shadow defendants or potential people behind the scenes, some of whom won't have the same knowledge of the English jurisdiction, to what extent should those acting on the part of claimants assume that the documents they draft or the correspondence that they send will be shared directly with an audience with less familiarity and, in effect, spell things out to save the first defendant perhaps that trouble or that additional communication barrier down the line?
Well, I'd say a responsible defendant knows if they've been brought into the courts of England and Wales will instruct an English firm and will take advice there. We do see cases quite often when that's not the case and you will be dealing directly with an overseas lawyer. Again, it's better dealing with an overseas lawyer than a kind of an insured, a supplier direct who's got no idea. So it would certainly be helpful. I wouldn't say it's necessary. It's not the obligation of the claimants. The package travel regulations are there to help the claimants. You are dealing with an English defendant. It should be more the obligation on the defender's side or the defendant's insurer's side to make sure that is explained. And if they are a responsible defendant, they will certainly get advice in England and Wales. And if not, it's almost their own fault if they are taking no advice or bad advice.
Yes.
If the government were funded to, in the review of the package travel regulations, put in place compulsory insurance requirements or particular structures within compulsory insurance requirements, be that excess limits or insolvency protections or the like, would that make the indemnity job harder or easier or both at the same time potentially for different reasons?
We could obviously, our government can legislate for suppliers based in different countries, so that's going to be the issue, isn't it? It's still going to be the issue of the tour operator who's got a strong indemnity, but we can't legislate over what level of insurance a supplier has. So I don't think it's going to help too much if we do. It'd have to be, well, Brexit's made the issue, hasn't it? It'd have to be a European-wide if we were within Europe to get any benefit, really. So.
I was gonna, yeah, just from my own experience of being, I guess, a defendant lawyer, the cost thing really resonates. And what we got quite a lot was, you want to settle this claim, well, how much are the costs? You know, and even in kind of low value cases, that can be quite tricky, particularly because it wasn't a fixed cost claim, for example, if it's low value loss track, as it was there. And I guess the question is, there's a lot of talk about how claims can help their clients and the defendants on this process. As frustrating as that might be for us as claimant lawyers, but what about cost inclusive offers? You know, do you think that the foreign insurers are actually receptive to those? Because obviously it's pretty tricky and potentially conflict supplying and their solicitors against each other in some of these circumstances. So it can be quite difficult to advise. But is that something which you think that your clients would
Definitely,
find? Yeah.
100%. It's something which I know claimants don't really like, the reasons you just explained there. But from our perspective, it makes it much easier from our perspective. The insurer wants to see that overall exposure. As Sara-Jane pointed out, lots of foreign insurers don't understand. You've settled the claim, then you might have 6-12 months where you're arguing over costs.
You know, they're flabbergasted by them, and it would be much better to, as far as it's very difficult because the claimant solicitor can't really say, you don't want to say what the costs are because you don't know. Not until the cost draftsman has produced the bill of costs. So, but I think cost inclusive offers are very attractive to foreign insurance.
They find Part 36 absolutely alien as well, in my experience. It's very difficult to explain it to them in terms of what it's trying to achieve, what the rules say, and what the impact is. And it's very difficult to get across, particularly if you're dealing with a foreign insurer that might have, and some of the European insurers are quite hierarchical about this, might have several layers of authority depending on the value of the claim or the cost. You find yourself explaining Part 36, first of all, to the claims handler, then the claims handler's boss, and then the claims handler's boss's boss, and then they say, oh, we're going to ring up somebody on the board now. And you're thinking, well, I'm not quite sure how much Part 36 is going to make it that far. So this is why, in practice, it can be very difficult to get offers to work.
Any other questions? Well, thanks very much. I thought that was a really useful session. Just mentioning Part 36, and a lot of discussion about Part 36 on Twitter this morning, following a quick article in the Times about Hugh Grant. And Julian Moore has been posting quite a lot about it, to which a lot of correspondents have been saying that's fine, but he's blocked us all. We can't see what he's saying. Thank you very much.